Imagine you are just in a catastrophic accident. Like, it is entirely someone else's fault, and the injuries are so severe that you are knocked into a profound unconscious coma for, I don't know, 6 straight months.
Oh, wow. Yeah, that's incredibly grim.
Right. But here's the kicker. When the court finally calculates the damages that the negligent party owes you, they look at those 6 months of your life and they actually reduce your financial payout for pain and suffering.
Yep, they absolutely do.
I mean, the logic is because you were unconscious, you didn't consciously experience the pain, so compensating you for a feeling you didn't feel makes no sense. The law effectively gives the person who caused your horrific injury a financial discount, precisely because they injured you so badly you couldn't even stay awake.
It's one of the most jarring paradoxes you will ever encounter in this field.
Right.
We naturally view the law through a moral lens.
Of course, you assume worse injury equals a higher punishment.
Exactly. We assume the worse the injury, the higher the punishment for the wrongdoer. But tort law isn't about punishment at all. It's a compensatory mechanism.
So it's just about putting things back to normal.
Right. It aims to put the claimant back in the position they would have been in, as best as money can. If you are entirely unaware of your surroundings, you aren't experiencing the anguish.
That is just so cold.
It is cold. However, the law does recognize the objective loss of time. They call that the loss of amenity. So you are compensated for losing 6 months of your life's normal enjoyment.
Okay, that softens the blow a little bit.
A little, yeah. But the strict calculation of pain and suffering requires actual conscious suffering.
Which perfectly sets the stage for our mission today. If you are preparing for the SQE1, tort law can feel like this massive, contradictory beast.
Oh, absolutely. It's a minefield.
You read a rule that seems rooted in common sense, and the very next page introduces an exception that feels entirely ruthless. So today, we are strategically deconstructing the foundations of tort law.
Specifically taking insights from a targeted SQE1 revision guide on Part 1.
Exactly. We are going through intentional torts, the intricate mechanics of negligence, the cold calculation of economic and psychiatric loss, the whole web of workplace liability, and finally, remedies.
And we really want to unpack the underlying logic, right? The why and the how. So that when you sit down for the exam, you aren't just reciting definitions, you're actually navigating the traps.
Right. Because memorizing definitions won't save you.
No, the examiners know that memorization is brittle. I mean, a student who merely memorizes a textbook definition of negligence will shatter the moment the facts of the scenario are slightly twisted.
Because it's all about application.
Precisely. The SQE is a test of application. It requires you to look at a highly deceptive fact pattern, isolate the specific legal mechanism at play, and apply it without getting distracted by moral outrage or, sympathy for the claimant.
Which is hard when the scenarios are so sad.
It is. But to survive the exam, you have to understand the boundaries the courts have drawn, and more importantly, why they drew them there.
Okay, let's unpack this by starting where the boundaries are the most literal. Intentional torts, and specifically the trespass trap.
A great place to start.
Before we can grapple with accidental harm and negligence, we really have to establish the baseline of intentional harm. So the foundational rule for trespass to land is that it requires a direct interference with someone's exclusive possession of land.
Right. If I have the legal right to control a piece of property, and you directly interfere with that right, you are a trespasser.
But the operative concept there is the directness of the interference, isn't it?
Yeah, that's key. When analyzing a fact pattern, you are looking for immediate physical invasion. That could be a person climbing a fence and walking onto the grass.
Or throwing something.
Exactly. It includes deliberate physical acts that project onto the land. So throwing a heavy rock over a fence, digging a subterranean tunnel that encroaches under the property line, or even flying a drone low enough that it breaches the specific airspace the landowner legally controls.
Wait, airspace counts.
It does. It is the physical, tangible crossing of a boundary, whether that's ground, below ground, or immediately above it.
Wow. Okay, but the word intentional is doing a lot of heavy lifting here, and it's highly misleading to me.
How so?
Well, if I hear intentional tort, my instinct is that the defendant must have possessed a guilty mind. Like they must have intended to commit a legal wrong.
I see where you're going.
Let's say I'm hiking in the Peak District. I have an ordnance survey map. I'm being incredibly careful, but the map is outdated. I step off what I genuinely believe is a public footpath and walk 10 paces into a private, unmarked, unfenced farm. I had zero intention of trespassing. My intent was purely innocent.
Right, and the innocence of your motive is entirely irrelevant to the tort of trespass.
Entirely irrelevant.
Entirely. The intent requirement in trespass does not mean the intent to break the law, nor does it mean the intent to infringe on someone else's rights. It strictly means the intent to perform the physical act that resulted in the trespass.
So because I meant to put my foot down?
Exactly. Did you intend to place your foot on that specific patch of ground?
Yeah.
Yes. Your nervous system fired, your muscles moved, and you intentionally stepped there. The fact that you were mistaken about the legal status of that dirt is no defense at all.
That feels so strict.
It is strict liability, essentially. The law rigidly protects the landowner's right to exclusive possession, placing the burden of geographic accuracy entirely on the person moving through the world.
Okay, that strict application makes sense for a mistaken hiker, but let's complicate it with implied or explicit permission. Let's look at the invitation trap that examiners apparently love.
Oh, they do love this one.
If a landowner explicitly invites me onto their property, say, for a dinner party, they have surrendered their exclusive possession to some degree, right? I have a license to be there.
Correct. You are a lawful visitor.
I like to use a vampire analogy here.
A vampire analogy? Okay, let's hear it.
Well, if you invite a vampire onto your front porch, they are legally protected from a trespass claim while on the porch. But if they decide to walk through the front door, head upstairs, and rummage through your bedroom closet, the original invitation surely doesn't cover that.
That is actually a perfect analogy.
Well,
the legal architecture of an invitation is bound by scope. Permission to enter land is not a universal passport to roam wherever you please.
it's limited.
Geographically and purposively limited.
Yeah.
If you're invited to a dinner party, the implied scope of that invitation includes the dining room, the living room, and the guest bathroom. It absolutely does not include the host's private home office or the locked garden shed.
So what happens the moment I open that shed?
The exact millisecond you step beyond the permitted zone, your legal status irrevocably changes. You are no longer a lawful visitor. You are a trespasser.
Just like that.
Just like that. And this distinction becomes critical when analyzing occupier's liability later on, because the duty of care owed to a lawful visitor is vastly different from the duty owed to a trespasser.
So the examiners will test this.
Without a doubt. The SQE will deliberately include a scenario where a person is invited into a shop, wanders into the staff-only stockroom, and gets injured. You must immediately recognize the shift in their legal status.
Got it. Now, contrast that direct invasion with nuisance. These two concepts are adjacent, but mechanically distinct.
Right. If trespass requires direct physical entry, nuisance governs indirect interference with the enjoyment of land.
Think of nuisance as an invasion of the senses or the environment, rather than a physical crossing of the boundary, right?
Exactly. If a neighbor builds a massive industrial compost heap right on their side of the property line, they haven't trespassed. They haven't crossed the line.
But the smell.
But the putrid smell drifting across the boundary, or the swarms of flies, severely interferes with your ability to use and enjoy your garden.
What about noise?
Same thing. Continuous deafening noise at 3 in the morning, or heavy vibrations from construction equipment that crack your plaster. These are indirect interferences.
So the exam mnemonic is straightforward here. Trespass requires direct invasion, and nuisance requires indirect interference.
Keep that in your back pocket for the exam.
Let's carry that concept of directness over from property to the human body. Battery.
Battery.
Colloquially, battery implies violence, right? A bar fight, a mugging, a vicious attack. But the legal threshold for battery in tort is far more sensitive than that. The formula is the intentional, direct, and unlawful application of force to another person.
The friction here lies in how the law defines force. It is completely divorced from the concept of causing physical injury or pain.
Wait, you don't have to hearse them.
Not at all. In the context of battery, force simply means any physical contact that is unwanted and goes beyond the bounds of generally acceptable everyday conduct.
Okay, so if I'm navigating the London Underground during the morning rush hour and a wave of commuters pushes me into the person standing next to me, that is technically an unwanted application of physical contact.
It is, yeah.
But it's not battery because jostling on a crowded train is an assumed risk of everyday urban life. It's legally acceptable.
Exactly. However, change the context slightly. You are on the same crowded train. You are frustrated by the delay. To get to the doors faster, you deliberately place your hands on the shoulders of the person in front of you and firmly shove them aside.
But they don't fall or get hurt.
They don't fall, they aren't bruised, they are just moved out of your way. That is battery.
Really? Just moving them.
Because the contact was intentional, it was direct, and crucially, because it exceeded the acceptable norms of everyday social interaction, it was unlawful force. Furthermore, battery doesn't actually require flesh-to-flesh contact.
Right. If I lose my temper in a library and throw a heavy textbook across the table, striking you in the chest, I haven't physically touched you with my hands.
No, but you intentionally set a physical object in motion with the direct result of it striking you. That fulfills the criteria just as effectively as a punch. Intentional, direct, unlawful force.
Okay, so we have established the baseline of deliberate acts. The law holds people strictly accountable when they intentionally cross property lines or intentionally apply force to others.
Yes.
But society isn't primarily damaged by malice, is it? It is damaged by carelessness. Which brings us to the overwhelming core of tort law.
Negligence.
Yes, negligence. If intentional torts are the foundation, negligence is the skyscraper built on top of it. And the most dangerous mistake an SQE candidate can make is treating negligence as a generalized concept of, someone doing something stupid and causing harm.
That's a great way to put it. It's not a vibe. Negligence is a highly rigid sequential chain of 4 distinct legal links.
And if you break one link?
If the claimant fails to prove even one of these links, the entire chain disintegrates and the defendant walks away free.
So the 4 links are duty, breach, causation, and damage.
You cannot jump ahead. You cannot look at a horrific injury, feel deep sympathy, and immediately conclude the defendant is liable. You must begin at the first link. Did the defendant owe the claimant a recognized duty of care in the eyes of the law?
For a vast majority of exam questions, this link is practically pre-forged, isn't it? The law has a catalog of established duty situations.
Oh, definitely. A medical professional unequivocally owes a duty of care to their patient. A motorist owes a duty to other road users and pedestrians. An employer to an employee. A teacher to a student.
So if you see one of those,
if the fact pattern presents one of these classic relationships, you don't waste time proving a duty exists. You just acknowledge it and move rapidly to the breach.
But the examiners will inevitably throw a curveball, a scenario so bizarre or unprecedented that it doesn't fit into any established category. A novel duty situation.
When faced with a novel scenario, the court does not simply guess. They apply a rigorous 3-stage test to determine if a duty should be conjured into existence.
The Capera test, right?
Yes. Though modified over the years, the principles hold. First, they ask if the harm to the specific claimant was reasonably foreseeable.
Could you see it coming?
Right. Second, was there sufficient proximity, a close legal or physical relationship between the defendant and the claimant? Third, and this is the crucial public policy lever, is it fair, just, and reasonable to impose a duty in these specific circumstances?
That third prong, fair, just, and reasonable, always strikes me as the judiciary giving itself a ripcord to pull if things get out of hand.
That's exactly what it is.
Even if I can foresee that my careless action might hurt someone standing 3 feet away from me, the court can look at the broader societal implications and say, if we hold this person liable, we open the floodgates.
Or we paralyze a crucial industry. Or we force public services to become too defensive. It's a vital mechanism to protect society from infinite liability.
Like with the police, right?
Yes. The courts are acutely aware of the chilling effect of liability. They use that third prong to shield police forces investigating crimes or rescue services operating in extreme conditions, where imposing a strict duty of care would result in hyper-defensive, inefficient public operations.
That makes sense. But the most philosophically agonizing area of duty involves doing absolutely nothing, the law of omissions.
This is where morality and the law diverge sharply.
Yeah, morally, our society is built on a framework of mutual aid. If I am walking past a shallow ornamental pond in a park and I see a toddler face down in the water drowning and I am a perfectly capable swimmer, morality dictates I must intervene.
Obviously.
If I simply sit on a bench, eat my sandwich, and watch the tragedy unfold without lifting a finger, I am morally abhorrent. Legally,
under the common law of England and Wales, you have committed no tort whatsoever. None. There is no general duty to rescue. There is no Good Samaritan law that compels a random bystander to intervene to prevent harm caused by a third party or a hazard they did not create. The law draws a sharp line between misfeasance actively doing something wrong and nonfeasance failing to act. You cannot be sued for pure nonfeasance unless a specific legal exception applies.
Okay, those exceptions are usually rooted in a pre-existing relationship or a deliberate assumption of responsibility.
Exactly. If I'm the parent of that drowning toddler, my omission is a breach of duty. If I'm a hired lifeguard sitting by the pond, I have a contractual assumption of responsibility.
But let's look at an exam trap that perfectly illustrates the danger of intervening: the abandon rescue.
Oh, this is a classic.
Let's say I'm just a random bystander. I see the child in the water. I have no duty to act, but my conscience flares up. I shout, "Don't worry, I'm coming." I drop my bag and wade into the water. A crowd of other bystanders gathers on the edge, but they don't jump in because they see I'm already handling the rescue.
They step back.
Right. But halfway to the child, I realize the water is freezing, it's ruining my expensive trousers, and I simply change my mind. I turn around, wade back to the shore, grab my sandwich, and walk away. Since I never had a duty to begin with, and all I did was walk into the water and walk out, haven't I just returned to my original state of legal immunity?
What's fascinating here is that the court will aggressively dismantle that defense. The moment you shouted and waded into the water, you altered the dynamics of the situation.
Because I made the others think I had it handled.
Exactly. By initiating the rescue, you effectively signaled to the rest of the crowd that the situation was under control, deterring other potential rescuers who might have actually saved the child. You didn't just fail to improve the victim's situation, you actively exacerbated the danger by isolating them from other help.
Wow.
Through that action, you assumed a responsibility, and your subsequent abandonment was a breach of a newly minted duty of care. The SQE rule is crystal clear.
Well,
You do not have to start a rescue, but if you do, you must not make the victim's position worse.
that is so counterintuitive, but logically it holds up. And there is a final nuance to the duty of care before we move down the chain. It's not just about proving a duty exists, it's about mapping the perimeter of that duty, the scope of duty.
Yes, the harm suffered by the claimant must actually fall within the specific protective scope of the duty owed. A defendant isn't a universal guarantor of a claimant's safety just because some duty exists between them.
Give me an example of that.
This often arises in professional negligence. If a surveyor is hired to assess whether a building is structurally sound, their duty of care relates to the physical integrity of the property. If they carelessly miss a massive crack in the foundation, they are liable for the repair costs.
Makes sense.
But if the buyer also loses money because the local housing market crashes an economic loss totally unrelated to the structural integrity, the surveyor is not liable for that market loss. The market fluctuation falls entirely outside the scope of the duty that they assumed.
Okay, assuming we have solidly established a duty of care, we move to the second link: breach. We know the defendant had a legal obligation to act carefully. Now we have to measure if they actually fell short. We move from theory to reality.
And the tool the law uses to measure this is the objective reasonable person standard.
The word objective is the anchor here, isn't it?
It really is. The court does not care if the specific defendant was clumsy, tired, slow-witted, or trying their absolute personal best. The law strips away the defendant's personal idiosyncrasies and replaces them with a hypothetical phantom: the reasonable person.
Would a reasonable person placed in these exact circumstances have acted the way the defendant did?
Precisely.
But the reasonable person isn't an omniscient robot. The court uses a 4-part calculus to determine what the reasonable person would have done in that specific moment, right?
They weigh the likelihood of the risk occurring, the potential seriousness of the harm if it does occur, the practical cost and effort of taking precautions, and the social utility of the defendant's activity.
It is a dynamic balancing act. If you are organizing a local community sports day, an activity with high social utility, and someone gets hit by a cricket ball that clears a perimeter fence that hasn't been breached in 3 decades, the calculus heavily favors the defendant.
Because the likelihood was tiny.
Right. The likelihood of the risk was minuscule, the social utility was high, and the precaution required, like building a 50-foot dome over the park, is practically absurd. A reasonable person would not have taken that precaution, therefore, no breach.
But if you reverse those variables, say a company is transporting highly corrosive, toxic chemicals through a densely populated residential neighborhood, the social utility of the specific route might be low, but the potential seriousness of the harm is catastrophic.
The stakes are huge.
In that scenario, the reasonable person takes extraordinary, wildly expensive precautions. The standard of care scales with the danger.
Now, this objective standard faces extreme stress testing in the exams when applied to specific categories of people. Let's talk about the learner driver. This rule has always felt inherently unjust to me.
A lot of students feel that way.
A 17-year-old takes their very first driving lesson. They are behind the wheel, panicking, trying to figure out the clutch. They make a mistake and rear-end another car. The law judges that terrified 17-year-old against the standard of a reasonably competent, fully qualified driver with years of experience. How is that a fair application of the standard?
It feels unfair to the teenager. But tort law's primary function is the allocation of loss and the protection of the public, not the coddling of a novice.
Okay, fair enough.
When a learner enters the public highway in a multi-ton vehicle, they are participating in a highly regulated, inherently dangerous adult activity. The innocent pedestrian crossing the street, or the driver stopped at the red light, does not have a radar to detect the experience level of the cars around them.
They just expect safe driving.
They are entitled to expect a uniform, objective baseline of safety from every single vehicle on the road. If the law lowered the standard for beginners, it would effectively force innocent victims to bear the physical and financial cost of the defendant's learning curve. Therefore, the standard refuses to drop.
So inexperience is never a defense. You are judged by the standard of the activity you choose to undertake. Which brings us to professionals. Doctors, lawyers, engineers. They are not judged by the standard of the reasonable person on the street.
No, a neurosurgeon is judged against the standard of a reasonably competent neurosurgeon.
But within medical negligence, there has been a seismic shift regarding a doctor's duty to warn a patient about the risks of a procedure, hasn't there?
Yes, a massive shift. Historically, the medical profession dictated what patients were told. If a body of doctors agreed that a specific risk wasn't worth mentioning, the court deferred to them.
The doctor knows best era.
Exactly. But the modern law has completely restructured this around patient autonomy. Following the Montgomery case, a doctor now has a distinct, affirmative duty to warn a patient of any material risks involved in a proposed treatment.
And the definition of material isn't decided by a medical textbook, right? It is assessed from the patient's perspective.
That is the crucial change.
If an eye surgery carries a 1% risk of permanent double vision, a doctor might think that's statistically negligible. But if the patient is a professional watchmaker or a pilot, that 1% risk is career-ending. To that specific patient, the risk is profoundly material. The doctor must inform them or they breach their duty of care.
It completely reframes the consultation. The doctor must take reasonable care to ensure the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments.
What about age? Does a 9-year-old child get judged objectively against a 30-year-old adult?
No, children are the primary exception to the strict adult objective standard. A child is judged against the standard of a reasonable child of the exact same age. A 12-year-old playing tag is only expected to exhibit the foresight and caution of a typical 12-year-old.
Unless, and here's the exam trap, unless the child is engaging in an adult activity.
Yeah, watch out for this one.
If a 14-year-old finds the keys to a tractor on a farm and decides to take it for a joyride, they instantly forfeit the protective shield of childhood, right?
Because driving a tractor is an adult activity. The moment they turn the ignition, the law snaps the standard of care all the way up to the reasonable, competent adult driver. Child plus ordinary childhood activity equals reasonable child. Child plus adult activity equals adult standard.
Brutal, but necessary.
Very necessary. Before we close the chapter on breach, we really must address the evidentiary lifeline known as res ipsa loquitur.
The thing speaks for itself.
Yes, in standard litigation, the claimant bears the burden of proving exactly how the defendant breached their duty. But sometimes, accidents occur in a vacuum of evidence.
Imagine a patient goes into surgery to have their appendix removed. They are fully under general anesthesia. When they wake up, they discover a surgical sponge has been left inside their abdominal cavity, causing a massive infection.
A nightmare scenario.
The patient was unconscious. They cannot possibly point to which specific nurse or surgeon dropped the sponge or exactly at what minute the protocol failed. Under normal rules, their inability to prove the specific mechanism of the breach would doom their claim, wouldn't it?
It would. This is exactly where res ipsa loquitur activates. The court acknowledges that surgical sponges do not magically materialize inside patients' abdomens unless someone in the operating theater was negligent.
Right, it doesn't just happen.
The criteria are strict, though. The accident must be of a type that does not normally happen without negligence, there must be no known explanation for the accident, and the instrument causing the damage must have been under the exclusive control of the defendant.
And what happens when it's invoked?
When invoked, it effectively forces the defendant to explain how the accident happened without their negligence. If they can't, the breach is inferred.
Okay, duty established, breach proven. Now we hit the third link, which is where cases become incredibly tangled. Causation and remoteness. Proving someone acted carelessly isn't enough. You have to prove their specific carelessness directly caused your specific injury.
The foundational test is factual causation, famously known as the but-for test. You ask a hypothetical question, but for the defendant's breach of duty, would the claimant have suffered the harm?
If a driver runs a red light and shatters a cyclist's collarbone, we ask, but for the driver running the red light, would the collarbone be shattered? The answer is no. Factual causation is satisfied.
The but-for test works flawlessly in simple linear accidents. But the law gets incredibly muddy when multiple causes converge.
Right, the complex case.
Imagine an industrial worker who develops a severe respiratory disease. Over a 30-year career, they were exposed to toxic dust by 3 completely different successive employers. It is scientifically impossible to determine which specific dust particle from which specific employer actually triggered the disease.
That sounds like a legal nightmare.
It is. If you apply the strict but-for test to employer A argues, even if you hadn't worked for me, you still would have gotten sick from employers B and C. If every employer uses that defense, the claimant gets nothing, despite entirely innocent behavior.
That can't be the end of it, though.
To prevent this catastrophic unfairness, the courts utilize the doctrine of material contribution. If the claimant cannot prove but-for causation because of complex overlapping causes, they can still succeed if they prove that the defendant's specific breach materially contributed to the risk of the injury or the injury itself.
So the examiner will test this by presenting a scenario with multiple bad actors.
Exactly. Your job is not to find the single dominant cause. Your job is to ask if the specific defendant in question made a material contribution to the overall harm. If yes, causation holds.
Now let's look at how defendants try to sever this link. The novus actus interveniens, a new intervening act. This is the argument that, yes, I started the chain of events, but something so wildly unpredictable happened afterward that it should cut off my liability.
The domino effect.
I view causation like a long line of dominoes. The defendant carelessly kicks the table, knocking over the first domino. They are liable for every domino that falls in that chain reaction. But if halfway through the sequence, a completely unrelated third party walks into the room with a baseball bat and smashes the rest of the table to splinters, the guy with the bat is the novus actus interveniens.
The chain is broken.
The original kicker is not liable for the splintered table, only the first few dominoes.
The visual of the bat is helpful because it highlights the threshold for breaking the chain. It must be unforeseeable and highly unreasonable. The most common SQE trap involves subsequent medical treatment.
Oh, I've seen this one.
Let's say you negligently run over my leg. I am taken to the hospital. While operating on my crushed leg, the surgeon makes a standard, everyday medical error. They prescribe a slightly incorrect dosage of antibiotics, and I develop a mild infection that extends my hospital stay. Does the surgeon's negligence act as a bat and smash the chain, letting you, the driver, off the hook for the infection?
The answer is unequivocally no. The courts rule that ordinary medical negligence does not break the chain of causation. If you put someone in the hospital through your negligence, the statistical reality is that hospitals occasionally make minor errors. It is a foreseeable risk of the situation you created.
Exactly. To break the chain, the medical intervention would have to be extraordinarily gross or palpably wrong, something so far outside the bounds of normal medical practice that it constitutes a completely new hazard.
Like intentionally giving the wrong drug.
Right. And the chain can also be broken by the claimant's own actions, but again, the bar is exceptionally high. If you break my leg and I decide to go bungee jumping 2 days later in a cast, snapping the bone entirely, my decision was so wildly unreasonable that it acts as a novus actus.
Because you did it to yourself, basically.
Right.
Assuming the chain of factual causation survives, we reach the final hurdle of the negligence framework: remoteness. The law recognizes that a single careless act can ripple outward, causing a butterfly effect of bizarre consequences. But it is not fair to hold a defendant infinitely liable for every unpredictable ripple.
No, it wouldn't be.
Therefore, the damage must not be legally too remote. The baseline rule is that the type of harm suffered must have been reasonably foreseeable to a reasonable person at the time of the breach.
If the type of harm is foreseeable, it really doesn't matter if the extent of the harm is far worse than anyone imagined, or if the exact way the harm occurred was unusual. As long as the general category of damage was predictable, the defendant is liable.
Which brings us to a massive philosophical clash in tort law: the eggshell skull rule. It is one of the most famous principles, and it fundamentally tilts the scales of justice toward the victim. The rule states, you must take your victim exactly as you find them.
Let's explore the friction here because it's fascinating. Imagine you and I are in a minor disagreement. You lose your temper and give me a relatively mild shove. To an average healthy person, this shove would cause nothing more than a bruised shoulder and momentary indignation. It is entirely foreseeable that shoving someone causes minor physical trauma.
Sure, a bruise is foreseeable.
However, completely unbeknownst to you, I suffer from a rare, severe genetic bone disorder. My bones are as brittle as glass. Your mild shove causes my collarbone, ribs, and arm to violently shatter, resulting in months of agonizing hospitalization, massive surgical intervention, and permanent disability.
From the defendant's perspective, this is a horrific injustice. You can stand in court and argue, my lord, the extent of this damage was entirely unforeseeable. A reasonable person could never have predicted that a mild shove would result in a shattered skeleton. The damage is too remote.
And the court will systematically reject that argument. This is where the eggshell skull rule overrides standard remoteness. The court asks one question. Was some physical injury, like a bruise, foreseeable from a shove?
Yes, it was.
Yes. Because the type of harm physical injury was foreseeable, you are liable for the full catastrophic extent of the damage, regardless of my hidden vulnerability. The philosophical underpinning is a stark binary choice. When a hidden vulnerability transforms a minor tort into a major tragedy, who bears the financial ruin? The innocent victim or the tortfeasor who wrongfully laid hands on them in the first place?
The law ruthlessly forces the tortfeasor to absorb the bad luck. Thin skull, still liable.
Exactly right.
We will return to that pro-victim philosophy later because when we discuss psychiatric harm, the law completely reverses its stance. But for now, we have successfully forged the negligence chain. Duty, breach, causation, damage. The claimant has built a fortress of a case.
But trials are adversarial.
Exactly. Now we flip the perspective. Section 5. Plain defense. How does a defendant dismantle a seemingly perfect negligence claim?
The most common and practically effective tool is contributory negligence. It is vital to understand that this is a partial defense. It is not designed to exculpate the defendant. It is designed to apportion blame. The defendant argues that while they were negligent, the claimant also failed to take reasonable care for their own safety, and this failure contributed to their injuries.
A textbook example. A driver is speeding significantly over the limit and strikes a pedestrian. The driver's negligence is undeniable, but the pedestrian was actively jaywalking across a busy intersection at night wearing dark clothing and staring at their smartphone.
A recipe for disaster.
The court will establish that the driver is liable, but then they will assess the pedestrian's contribution. They might conclude the pedestrian was 40% responsible for their own misfortune. The claimant still wins, but their final financial award is slashed by 40%. The memory trick is simple. You contributed, so your compensation is reduced.
Now compare that to a much more lethal legal weapon, volenti non-fit injuria, voluntary assumption of risk. Unlike contributory negligence, volenti is a complete, absolute defense.
Complete, as in zero payout.
Zero. If the defendant successfully proves it, the claimant receives nothing. Because the consequence is so total, the courts have constructed an incredibly high barrier to entry. The defendant must prove two distinct elements. First, that the claimant had full comprehensive knowledge of the specific nature and extent of the risk. Second, that the claimant freely and voluntarily agreed to incur that legal risk.
SQE examiners absolutely love setting traps around volenti, usually by conflating the knowledge of an inherent risk with consent to negligence. Let's use a ski resort.
Okay, let's hit the slopes.
I took a skiing holiday. I know that strapping slippery planks to my feet and throwing myself down an icy mountain is an inherently dangerous activity. I know I might catch an edge, tumble, and snap my femur. I possess full knowledge of the general risk of the sport. Now, let's say I get onto the chairlift. The lift operator is heavily intoxicated, pulls the wrong lever, and flings me 30 feet onto the concrete loading dock, shattering my legs.
Ouch.
Can the ski resort deploy volenti? Can they say, well, you voluntarily assumed the risk of getting hurt when you chose to go skiing, so you get nothing?
Absolutely not. And recognizing why is crucial for the exam. You consented to the inherent natural risks of the activity, the gravity, the snow, your own lack of skill. You emphatically did not consent to the independent, negligent act of a drunk employee operating heavy machinery.
Right, I didn't consent to their negligence.
Exactly. The claimant must have consented to the specific negligent act that caused the harm. It is incredibly difficult for a defendant to prove that a claimant willingly agreed to be the victim of negligence. Therefore, while volenti is powerful in theory, it rarely succeeds in practice outside of extreme scenarios, like willingly getting into a car with a driver you know is dangerously drunk.
What about illegality? The defense of ex turpi causa. If I am injured while I am actively committing a crime, does the law simply shut the courtroom doors on me?
It depends entirely on the nexus between the illegal act and the negligence. The defense prevents a claimant from recovering damages if their claim is inextricably linked to their own serious illegal conduct. But examiners will try to bait you into applying it too broadly.
Right. If I park my car illegally on a double yellow line and a distracted garbage truck driver violently rear-ends me, causing whiplash, the defense of illegality will fail.
Because the parking ticket has nothing to do with the whiplash.
My illegal parking is the background context, but it is not the proximate cause of the crash. The connection isn't close enough. However, if you and I decide to rob a bank and we are fleeing the police in a getaway car at 120 miles per hour and you, the driver, lose control and crash into a wall, paralyzing me, I cannot sue you for negligent driving.
Definitely not.
We were engaged in a joint, serious criminal enterprise. The injury is a direct manifestation of our illegal pact. The court will not regulate honor among thieves.
And before we move past offenses, we must address contractual exclusions. Commercial entities often try to bypass tort law entirely by writing exclusion clauses into their contracts. By signing this, you agree we are not liable for any negligence.
The law takes a sledgehammer to these clauses when physical safety is involved. Under the Unfair Contract Terms Act, 1977, any contractual term that attempts to exclude or restrict liability for death or personal injury resulting from negligence is absolutely void.
It is legally radioactive.
You cannot contract your way out of killing someone carelessly. If the exam fact pattern shows a company trying to enforce a waiver against a grieving widow, you immediately know the waiver is void. For other types of loss, like property damage, an exclusion clause might survive, but only if it passes a rigorous test of reasonableness.
Okay, we are now executing a massive conceptual pivot.
Yes, Section 6. The intangibles. Pure economic loss and psychiatric harm. We're dealing with harm to bank accounts and harm to the mind. Up until this point, we have operated entirely in the physical world. Shattered bones, crushed cars, ruined lungs. Tort law is highly comfortable compensating physical damage.
But this is where the expansive compensatory nature of tort law hits a brick wall. The courts become highly restrictive, driven by a deep-seated fear of infinite, unquantifiable liability. Let's start with pure economic loss. The golden, overarching rule you must imprint on your brain is this. Generally, pure economic loss is not recoverable in the tort of negligence.
The critical word in that sentence is pure. The law happily compensates consequential economic loss. If a negligent driver plows into my bakery delivery van, destroying the vehicle, they have to pay for the physical damage to the van.
Yes, the van is property damage.
But because the van is in the repair shop for 3 weeks, I can't deliver my cakes, and I lose 10,000 pounds in profits. That 10,000 pounds is economic loss, but it is directly consequential to the physical damage of my property. I can recover it. Pure economic loss is fundamentally different, right?
Pure economic loss means you have suffered a financial detriment without any corresponding physical damage to your person or your property. Imagine you are a factory owner. A construction crew working down the street negligently severs the main underground power cable. Your factory loses power for 3 days. You lose 50,000 pounds in production profits.
But the power cut didn't fry my machines. It didn't burn down my factory. The machines just sat there, undamaged, turned off.
Exactly. You have suffered no physical damage to your property. Your loss is purely financial. Under standard negligence principles, you cannot recover that 50,000 pounds from the construction company.
Which feels intensely frustrating for a business owner. The construction crew was clearly careless. My business undeniably lost money because of them. Why does the law suddenly pull up the drawbridge?
It is the ultimate expression of the floodgates argument. If the courts allowed recovery for pure economic loss, a single severed power cable in a busy financial district could result in billions of pounds of liability extending to thousands of businesses, stockbrokers, and remote contractors.
A domino effect of bankruptcy.
The liability would be disproportionate to the careless act of digging a hole. The court's philosophy is that if you want to protect your purely financial expectations, you should negotiate a contract, buy insurance, or seek warranties. Tort law protects your physical safety and your property. It is not an insurance policy for your profit margins.
But, as always, there is an exception. The major avenue to claim pure economic loss is through the doctrine of negligent misstatement. You can claim financial loss if it is caused by careless advice or information rather than a careless physical act.
The threshold, stemming from the famous Headley-Byrne case, is exacting. The claimant must prove that the defendant assumed a responsibility toward them and that the claimant reasonably relied on that statement.
This isn't about casual advice given at a pub. If I ask a professional financial advisor for guidance on an investment and they know exactly who I am, they know the specific purpose of the advice, and they carelessly recommend a company they failed to research properly, and I invest my life savings and lose it all.
You can sue them for that.
Right. I have suffered no physical damage, but I can sue them for negligent misstatement. The examiner's formula to look for is professional advice plus assumption of responsibility plus reasonable reliance.
Now we transition from the bank account to the brain. Psychiatric harm. Just like economic loss, we must strictly divide this into two categories: consequential and pure. Consequential psychiatric harm is straightforward.
Right, like if I get hurt physically.
You are involved in a terrifying train derailment. You suffer a broken spine. The trauma of the accident and the life-altering injury causes you to develop severe clinical PTSD. Because the psychiatric illness is anchored to a physical injury, the law treats it as general damages. You recover compensation smoothly.
But pure psychiatric harm, sometimes referred to colloquially as nervous shock, is a legal minefield. This occurs when a claimant suffers a medically recognized psychiatric illness, like clinical depression or PTSD, without suffering a single scratch physical injury.
Note that ordinary grief, fear, or distress are never enough. It must be a diagnosable psychiatric condition. To manage these claims, the law aggressively segregates claimants into two distinct castes: primary victims and secondary victims.
A primary victim is a person who was directly involved in the terrifying event. They were physically in the zone of danger. Even if they miraculously escaped physical injury, they were objectively at risk of it.
Like a near miss.
Imagine a pedestrian who is forced to dive violently out of the path of an out-of-control lorry. The lorry misses them by an inch, smashing into a wall. The pedestrian is physically unharmed but develops crippling PTSD from the near-death experience. Because they were in the zone of physical danger, they are a primary victim. As long as some physical injury was foreseeable, they can claim for their pure psychiatric harm.
But now we arrive at the secondary victim. This is a person who is completely safe from any physical harm. They were never in the zone of danger. Instead, they suffer their psychiatric trauma purely from witnessing a horrific accident happen to someone else.
And this is where I want to revisit that philosophical friction we discussed earlier with the eggshell skull rule. When dealing with physical injuries, the eggshell rule bends over backward to protect the fragile victim, forcing the defendant to pay for unforeseeable catastrophic consequences.
Right. Take your victim as you find them.
But when a secondary victim witnesses a tragedy and suffers profound psychological destruction, the law suddenly becomes a ruthless, unsympathetic bouncer. The law dictates that a mother standing safely on the pavement who watches a drunk driver run over her child cannot automatically claim for the psychiatric trauma she endures. The legal system erects an incredibly hostile obstacle course for her. Why this massive contradiction?
This raises an important question, and you are identifying the most acute tension in tort law. The contradiction exists entirely because of the fear of infinite liability.
The floodgates again.
Yes, a physical impact is naturally limited. A car can only hit so many people. But a visual impact is boundless. If a horrific accident happens at a packed stadium, 50,000 people might witness it. If the law allowed every traumatized bystander to sue, the defendant would be instantly bankrupted by the psychological ripples of a single mistake.
So they have to draw a line.
To prevent this, the House of Lords established the Alcock criteria. It is a rigid, unforgiving checklist designed specifically to whittle down the number of secondary victims to the absolute minimum.
To succeed as a secondary victim, you must satisfy every single element of a four-part test. A single failure means the claim is entirely dismissed. The memory trick is close, direct, foreseeable.
Let's break those down.
First, you must have a close tie of love and affection with the primary victim who was injured. The law presumes this for parents, children, and spouses. Anyone else, siblings, best friends, must explicitly prove the closeness of the bond.
Second, close proximity in time and space to the accident or its immediate aftermath. You must be physically there when it happens or arrive at the gruesome scene shortly after.
Third, direct perception of the event with your own unaided senses. You must see or hear the tragedy unfold firsthand.
And fourth, The psychiatric injury must be a reasonably foreseeable consequence for a person of normal fortitude. Note the contrast. The eggshell rule protects the physically fragile, but the secondary victim test demands you possess normal psychological strength.
The application of these rules is famously harsh. If that mother is informed of her child's accident over a telephone call, she fails the direct perception requirement and her claim dies.
Instantly.
If she rushes to the hospital but arrives 8 hours later after the child has been cleaned up and is in a stable ward, she fails the immediate aftermath test. The examiners will test your ability to enforce these cold boundaries despite the tragic facts of the scenario.
So remember, close, direct, foreseeable. Burn it into your memory.
Let's shift gears and look at the structural realities of litigation. Section 7, the workplace web employer's liability and vicarious liability. Everything we've discussed so far assumes the person who committed the tort is the one paying the damages.
Which isn't always the case.
Right. In reality, employees often don't have the funds to pay a massive settlement. Claimants logically look for the deep pockets, which is usually the employer.
There are two distinct legal avenues to extract damages from an employer. The first is primary liability. This is where the employer is sued for breaching their own personal, non-delegable duty of care to their employee.
An employer owes a direct duty to provide a safe system of work, competent fellow staff, safe equipment, and a safe workplace. This duty is expansive. If a logistics company hires a forklift driver who has a known, documented history of reckless driving and safety violations, and that driver subsequently runs over a colleague, the injured colleague doesn't just sue the driver.
No, they sue the company directly.
Exactly, for their negligent hiring practices. The employer breached their duty to provide competent staff. This duty even extends to psychiatric harm caused by workplace stress, provided the specific thresholds of foreseeability are met.
And within this primary liability, the SQE loves to test the Employer's Liability Defective Equipment Act, 1969. It is a brilliant statutory trap.
Let's construct the scenario. A construction firm buys a brand new, top-of-the-line industrial drill from a highly reputable third-party manufacturer. The employer does everything right. However, the drill has a hidden, latent manufacturing defect deep inside the motor. An employee uses the drill on site, the motor violently explodes, and the employee loses an eye.
Terrible accident.
My immediate instinct, applying common sense, is to say the employer is innocent. They bought a good tool from a good company. The injured employee should sue the manufacturer for product liability.
Common sense will fail you here. Under the 1969 Act, the employer is statutorily liable for the employee's injury, even though the defect was entirely the fault of the third-party manufacturer.
Really? Even though they didn't make it?
Yes. The legal policy is clear. The injured employee should not be forced into a complex, expensive legal battle against a massive, potentially foreign manufacturing corporation. The employer provided the defective equipment, so the employer pays the employee. The employer can then use their superior resources to seek an indemnity from the manufacturer later.
Oh, that makes sense. The exam tip. If an employee is hurt by a defective tool, do not let the employer off the hook just because they didn't build it.
That is primary liability. The employer did something wrong, or statute says they did. Now we look at the second avenue, vicarious liability. This is a form of strict liability. The employer has done absolutely nothing wrong. Their training is perfect, their hiring is flawless, their workplace is safe. Yet they are forced to pay for a tort committed by their employee.
Yeah, the foundational justification for this is that if an employer sets up a business to generate profit and that business introduces risks into society through its employees, the employer must bear the cost when those risks materialize into harm.
Yes, but the employer isn't liable for everything an employee does 24/7. The absolute hinge upon which vicarious liability swings is the salmon test. The tort must be committed in the course of employment.
Establishing that an employee is acting in the course of employment is easy when they are doing exactly what they are paid to do. If a delivery driver carelessly rear-ends someone while driving their route, the employer pays. But the boundaries of this rule are wildly elastic, even encompassing intentional and criminal acts.
Give me the bouncer example.
They have a bouncer at a nightclub. Their job description explicitly involves using physical presence and sometimes measured physical force to manage crowds and eject unruly patrons. If a patron becomes verbally abusive and the bouncer loses their temper, applying completely excessive, unlawful force that shatters the patron's jaw, that is battery. It is a criminal act.
But because the employment inherently authorized the use of force, the bouncer's wrongful act is deemed so closely connected to what they were authorized to do that it falls within the course of employment. The nightclub is vicariously liable for the assault.
The examiners will push this boundary further by introducing the concept of disobeying orders. Does an employee explicitly violating a direct rule sever the employer's liability?
This is a great area for exam traps.
This is one of my favorite legal mechanics. Let's say I own a logistics company. I hand the keys to my driver and I look them dead in the eye and state, company policy explicitly forbids unauthorized passengers. Under no circumstances are you to pick up a hitchhiker in the company van. If you do, you are fired.
Very clear instructions.
The driver leaves the depot, immediately sees a hitchhiker, picks them up, drives negligently, and crashes, severely injuring the hitchhiker. As the employer, I'm screaming at the court. I explicitly forbade the exact action that caused the injury. How can I be vicariously liable?
The court will analyze the nature of your prohibition. You have to distinguish between an order that limits the scope of the job, which is what the employee is employed to do, versus an order that merely regulates the method of the job, which is how the employee does the work.
So in my scenario,
The driver is employed to drive the van along the delivery route. That is the what. Picking up the hitchhiker was a blatant violation of how he was supposed to conduct himself on that route. But critically, when he crashed, he was still driving the company van on the company route, delivering company packages.
he was still doing his job.
He was performing his authorized job, albeit in a wildly unauthorized manner. Because he was still executing the what, the employer's liability is not severed.
The memory trick is what you're doing versus how you're doing it. If I hire an employee strictly to sweep the warehouse floors and I say, do not ever drive the forklift, and they jump on the forklift and run someone over, they have changed the what. Sweeping floors and operating heavy machinery are entirely different jobs. They've stepped outside the scope of employment, and I am not vicariously liable.
Exactly. But if I say, sweep the floors, but don't listen to music, and they put on headphones, get distracted, and trip someone with their broom, they were still doing the what, which is sweeping. They just did it wrongly. I am liable.
The final geographic boundary of vicarious liability is encapsulated in the phrase detour versus frolic. This dictates how far an employee can wander before the employer is safe.
A minor deviation from the authorized route is a detour. The employee is still deemed to be in the course of employment.
Let's return to our delivery driver. It's 2 p.m. He is on the clock. He decides to pull 2 streets off his main route to go through a fast food drive-thru. While ordering his burger, he negligently takes his foot off the brake and rolls into the car in front of him.
That is a minor detour. He is still generally working, just momentarily prioritizing his stomach. The employer is vicariously liable.
Yes. But a major independent departure is a frolic. If at 2 p.m. the driver decides he is bored, turns the van around, and drives 60 miles to the coast to spend the afternoon at the beach with his friends, and crashes in the beach parking lot, he has completely abandoned his duties. He is on a frolic of his own. The employer's liability is severed.
The exam trick. Detour equals slightly distracted but still working. Frolic equals completely abandoned the job for a personal adventure. Perfect. And a very brief but vital note on independent contractors. As a general rule, you are not vicariously liable for the torts of an independent contractor. If you hire an independent plumbing company to fix a pipe and they negligently flood the downstairs apartment, you do not face vicarious liability.
But do not let the contractor checklist trap catch you. The thought process must be, vicarious liability, no. Okay, did I breach my own duty? Even if you aren't vicariously liable for the plumber's mistake, you might be directly liable if you were negligent in hiring them.
If you hired a plumber who had no license, terrible reviews complaining of flooding, and you failed to check any references, you are personally negligent for your careless selection. Never forget to pivot back to primary liability.
All right, we have reached the final stage of our journey. Section 8, making it right, remedies, damages, and mitigation. We've established the tort, navigated causation, bypassed the defenses, and pinpointed the wealthy defendant. The judge bangs the gavel in favor of the claimant. How does the court translate a shattered life into a monetary figure?
We return to the fundamental philosophy we discussed at the very beginning. Tort damages are compensatory. They are not designed to punish the defendant. That is the realm of criminal law. The objective is restitutio in integrum, to restore the claimant, in financial terms, to the exact position they would have enjoyed had the tort never occurred.
But this isn't a blank check. The claimant has an active, ongoing responsibility known as the duty to mitigate their loss. A claimant cannot passively allow their damages to multiply and expect the defendant to foot the bill. If a negligent plumber causes a slow leak in your ceiling, you cannot just put a bucket under it, let it overflow for 3 months until the entire floor rots, and then sue for a whole new house. You must take reasonable steps to stop the water and minimize the damage.
However, the SQE frequently tests a very specific UK exception regarding physical injuries and mitigation. If a claimant suffers personal injury, they are legally permitted to seek treatment through private health care, even if free treatment was readily available through the NHS.
Wait, really? The defendant has to pay the private bill.
Yes. The defendant cannot argue that the claimant failed to mitigate their financial loss by choosing the expensive private option. The statutory rule protects the claimant's right to choose their medical care.
When calculating the actual payout, damages are split into two broad categories: special damages and general damages. This is entirely about the mechanics of calculation. Special damages are for financial losses that can be precisely mathematically calculated right up to the day of the trial. They are historical.
Like out-of-pocket expenses.
Right. I missed exactly 42 days of work. My salary is £100 a day, so I lost exactly 4,400 pounds. I spent 315 pounds on taxi fares to the hospital. It requires receipts and calculators.
General damages, on the other hand, require the court to look into a crystal ball. They cover future financial losses and non-pecuniary losses, things that cannot be objectively priced. How much is the pain of a broken spine worth? If a 25-year-old medical student is paralyzed, how much future income would they have earned over a 40-year career as a surgeon? It requires a general assessment based on judicial guidelines, actuarial tables, and estimations.
Which brings us back to our opening scenario: compensating the intangibles. Under general damages, a claimant receives an award for pain, suffering, and loss of amenity, often abbreviated as PSLA. We already explored the coma paradox, that a completely unconscious victim cannot claim for pain and suffering because they did not consciously experience it.
But let's focus on the loss of amenity portion. This compensates the claimant for the reduction in their ability to enjoy the normal activities of life. This is assessed objectively. If the accident amputates a claimant's hand, they receive a baseline payout for the physical loss. But if the court discovers that the claimant was an avid, passionate amateur pianist, the loss of amenity award will be significantly increased.
They haven't just lost a hand, they have lost a specific, profound source of joy in their life. The court attempts to put a price tag on a stolen hobby.
Finally, we must address the most somber calculation: death claims. What happens when the claimant's injuries prove fatal before the trial concludes? The law handles this by splitting the litigation into two separate types of claims.
First, there is the claim that belonged to the deceased victim. Under the Law Reform Miscellaneous Provisions Act 1934, the victim's existing cause of action survives their death and transfers to their estate. The estate can sue for the special damages the victim incurred before they died, like hospital bills, and for the pain and suffering the victim experienced between the accident and their passing.
Second, there are the claims brought by the surviving family members, governed by the Fatal Accidents Act 1976. These are claims for loss of dependency. A surviving spouse can sue the defendant for the financial support they lost because their partner was killed.
There is also a statutory award for bereavement damages, which is a fixed lump sum. But this is a massive exam trap, isn't it?
It absolutely is.
Bereavement damages are not available to just anyone who is grieving. The statute is ruthlessly narrow. It is restricted exclusively to a spouse, a civil partner, a qualifying cohabiting partner of at least 2 years, or the parents of a minor child. If a 25-year-old unmarried person is killed, their devastated parents cannot claim statutory bereavement damages because the child is no longer a minor. It is a harsh, rigid statutory boundary.
Which is why, when faced with a fatal accident scenario on the exam, you must systematically ask 3 questions. Who is the specific person trying to claim? What specific type of loss are they claiming, estate versus dependency? And does the governing statute actually grant that specific person the legal right to claim?
And with that, we have traversed the massive landscape of Tort Law Foundations Part 1. We have navigated the direct invasions of intentional torts, meticulously built and broken the negligence chain, weighed the philosophical boundaries of psychiatric harm, tangled with vicarious workplace liability, and calculated the final damages.
To consolidate this entire deep dive, we are going to synthesize it into the ultimate rapid-fire 6-step exam framework provided in the revision materials. When you sit down for the SQE, before you read a single question, sketch this framework out.
Step 1. Is there a duty? Identify established duties immediately or rigorously apply the three-stage test for novel scenarios, keeping an eye out for omissions and exacerbated risks.
Step 2. Was there a breach? Apply the objective standard of the reasonable person, adjusting for special categories like children or professionals, and use the four-part risk formula.
Step 3. Did the breach cause the harm? Run the but-for test, check for material contribution in complex cases, and look out for novus actus interveniens, remembering that ordinary medical negligence doesn't break the chain.
Step 4. Is the damage too remote? Ensure the type of harm was reasonably foreseeable, but never forget the eggshell skull rule forces the defendant to pay for hidden vulnerabilities.
Step 5. Is there a defense? Check if the claimant contributed to their own loss. Assess if they explicitly consented to the specific negligence under volenti, or if illegality severs the claim.
Step 6. What losses can be recovered? Delineate between special and general damages, check for mitigation, and apply the strict statutory rules for fatal accidents.
My final piece of advice: trust the framework, not your emotions. The SQE examiners are architects of misdirection. They will write a heartbreaking 200-word paragraph detailing a claimant's tragic injury designed specifically to elicit your sympathy. But buried in the middle will be a 5-word sentence stating the claimant ignored a massive, flashing warning sign. Do not jump to a conclusion because you feel bad for the victim. Spot the legal mechanism. Apply the rule cold.
That's the best advice you can get.
But before we sign off, I want to leave you with a final provocative thought that builds on that philosophical friction we explored. We talked about the incredibly rigid, unforgiving Alcott criteria for secondary victims in psychiatric harm. The law demands direct perception with your own unaided senses to prevent the floodgates of liability from opening.
Right, they have to be there.
But consider the reality of the technological world we inhabit right now. We live in an era where distance has collapsed. We experience our loved ones' lives live streamed on our phones. We watch their daily commutes on video calls. We track their locations in real time.
Where are you going with this?
Well, how long can the common law realistically maintain that watching a horrific tragedy unfold live, in high definition through a digital screen, isn't direct enough to cause foreseeable, profound psychiatric trauma? As technology completely redefines what it means to be present with another human being, the law of tort will inevitably be forced to decide if a pixelated reality is just as damaging and just as legally valid as a physical one.
Wow. It is the exact type of novel duty question that will undoubtedly shape the next century of negligence jurisprudence, forcing the courts to balance human empathy against the perpetual fear of the floodgates.
Something to mull over as you close your books today. Thank you for joining us for this expensive deep dive into the foundations of tort law. Keep the framework in mind, trust your analysis, and we will see you on the next deep dive.